첫 번째 기조 강연을 해주실 분을 모시도록 하겠습니다. 영국 체러티 커미션에서 오셨습니다. 케네스 데블 국장님입니다. 뜨거운 박수 부탁드립니다.
Good morning and thank you. I just introduced myself. I'm Kenneth Dibble. I'm the Chief Legal Advisor of the Charity Commission for England and Wales. I won't say too much about the Charity Commission at the moment because some of the subject of today, what I'll be talking about, and tomorrow will be going into some detail about how we regulate charities in the United Kingdom, and I'll save that for then. Can I first say in opening, for myself and for the Charity Commission, our appreciation and congratulations of the National Council for MPO's career and the Ministry of Health and Welfare to bring about this conference, which I think marks a recognition and value of the need to regulate MPOs, not only in Korea, but generally worldwide. And I think they are to be congratulated on bringing about this conference. And in particular, we at the Charity Commission are very grateful to be invited to this conference. We believe that this recognises the development of regulation of charities in the United Kingdom, and it is a mark of respect for how far we have come in our long journey to regulate charities. In the brief addresses this morning, I thought one of the most significant facts which were stated was the transition of South Korea from a country which receives aid to a country, a donating country, which exports charitable relief abroad. And that struck me as a turning point for a country and a mark of its development, that in a sense it's recognised its part in the world community to help others in other countries who are less fortunate than themselves, and a mark of respect both to the individuals in this country and government and all who work in the MPO sector as a means of transition of the country and of civil society in southern Korea. Now the address I'm going to give today is positioned, I apologise for this, but it's very much from a regulatory and technical perspective, and if you can bear with me on that. I first want to talk about the principles which underlie the regulation of MPOs and charities in a broad sense, and which apply worldwide in one form or another. And then I want to talk about how we regulate, an overview of how we regulate charities in the United Kingdom. And I say an overview because tomorrow I will go down in much more detail about what we do in the UK for your information, and whether or not such a process we have could be adapted in one way or another for Korea. To start, I want to talk about the value of charity and MPO sector worldwide. Most developed countries, and even some underdeveloped ones, recognise the value of NGO activity and the need to regulate it. The scope is vast. Charities and associated non-for-profit organisations produce an economy of over $2.2 trillion US. That's a figure Hopkins University produced some years ago, and I'm sure it's in excess of that now. And to put that in a perspective, that's equal to the 7th largest economy in the world. And if you think about that significance in terms of its contribution to the economy worldwide, there is a strong tradition of voluntary giving to support the least well off in most countries. It's essentially had religious origins, but is now in part well secularized internationally. North America, the European Union, Korea, Japan, India, China, the Gulf states are some of the countries where altruism and charitable giving are well developed. This leads ultimately to a voluntary sector which stands aside the state sector and the private sector as a significant force in those economies. And indeed, the charitable sector, or MPO sector, has become a vital part of the social economy in most countries and is responsible for both domestic and international contribution, as we have heard from Korea. It's active in all social fields: humanitarian relief, health, education, social welfare, the arts and religion. It has a both domestic and international context: domestic in terms of capacity building and a contribution to civil society in the country where it operates, and growth of international aid. The speed of growth in the MPO sector worldwide has taken many governments by surprise, and there's a growing recognition of the need to regulate this sector. But governments do not always have the regulatory bodies to take on this role. And new regulatory approaches by governments have often led to tensions between MPO communities and the government itself. And you see that significantly in certain countries of the world where there is concern about the MPO sector and the role of the MPO sector in those countries. I now want to touch on some political and constitutional issues. These issues relate to the need for states to recognize the value and contribution and the development of civil society through a thriving MPO sector. There is a real need for the state to recognize the role and value of MPOs. Many states do not recognize them as a generic unit of the social economy in themselves. But that is the first step, not only to the success of an MPO community, but also success in regulation. States ought to recognize also the need for the rights and freedoms of individuals to associate, the freedom of association, to form organizations for voluntary social welfare and religious purposes. And they need to encourage altruism through citizenship, through volunteering and financial support for MPOs and charities. And in return, the state needs to support MPOs, both in the form of fiscal reliefs, financial reliefs, or other immunities and benefits. It's a two-way street. The state needs to encourage the growth of the MPO sector, and that's an important aspect of any development regulatory system. I now want to look at the supportive legal frameworks which either need to exist or need to be created in order that MPOs can flourish and that they can be regulated. There needs to be within any society legal forms which have distinguishing features for MPOs and charities. There needs to be a supportive jurisprudence or a legal basis for their regulation. Laws need to be created or adapted to support that. And the regulation needs to be underpinned by notions of accountability and transparency. And that's absolutely critical as we see it in the United Kingdom for a successful charitable sector and successful regulation of that sector. And regulation must not be just interventionist by the state. It must be supportive, and it must support effective governance and operational effectiveness of MPOs. And regulation must permit aspects of support as well as censure and intervention by relevant regulatory agencies. I now want to look at the legal forms and distinguishing features of MPOs, and these are relatively common worldwide, or elements of them are, but they are not always consistent between states. Charities and MPOs must be legally capable of recognition. They can take the form of associations, societies, trusts, corporate bodies, cooperatives, or whatever legal form which is accepted in any particular state or jurisdiction, but they must be capable of recognition. They should be independent organizations. They should be non-profit distributing in terms of their status. That marks a distinction between them and commercial organizations. And they should be formed for a social purpose, formed for an altruistic, public, social purpose, which is of recognized social value in the state concerned. And these legal forms are supported by specific or general jurisprudence. I want to now turn to the purpose of MPO regulation. As we see it in the United Kingdom, and I think more generally accepted worldwide, that regulation is directed at promoting public trust and confidence in the MPO sector. The purpose of regulation, at least as we see it, is to create a healthy sector in terms of its social and economic contribution to society and the support and development of civil society and communities. That's the role of regulation. That's the overarching role of regulation. And this will maximize social engagement through volunteering and financial giving, which is supported by the state conferring fiscal benefits on MPOs and charities. But above all, it should be regulation which is not specifically in the interests of the MPO sector. It's indirectly in the interests of the MPO sector, but directly it's regulation which is in the public interest, because it is the public which support and contribute to MPOs and charities and their success. In terms of regulation itself, regulation takes place in all forms of advanced economies in many areas: public health, financial, economic, price regulation, and can be directly carried out by government or by quasi-independent bodies of government, or fully independent of government, or by sector-led institutions, self-regulation. As I said, regulation is generally for a purpose. It's not for the sake of regulation in its own right. So, for example, if you have regulation for consumer protection, for liquidity in banks, to protect the environment, or to comply with laws and regulations which govern any particular sector. As we see it, the overarching purpose of NGO regulation is to produce an environment of public trust, where NGOs are both compliant with law and regulation and can flourish as organizations. I've listed on the slide some core elements which might be found to exist for any good regulatory system in any state regulating its MPO sector. First of all, there has to be the existence of a regulatory authority or authorities. The Charity Commission in England and Wales is quite unusual in that it is a unitary regulator. There are no other regulators specifically for charities, but in many countries the regulation of MPOs are found in a number of governmental organisations. Next, there's the recognition of MPOs through a registration system. And normally this should take the form of a public registration system with clear definitions about registration requirements. What is or is not an MPO which can be registered? In addition, there must be publication of clear and understandable rules which govern the operation of MPOs. MPOs cannot be held to account for things they do wrong if they do not know what the rules are to begin with. And as we see it, it's the role of the regulator to set out those rules very clearly. Accountability and transparency is absolutely key to effective regulation, and that should be promoted through a regulatory infrastructure which requires the submission and public availability of financial returns about MPOs and permits their monitoring, and monitoring not only by the regulator or the regulatory authorities, but monitoring by ordinary members of the public who want to understand what a particular MPO is doing with the money it's been given. And that monitoring should extend by the regulator to the assessment of complaints where MPOs are found to breach the rules, and there needs to be clarity about when the NPO itself can be investigated by the regulator. There must be clearly defined circumstances. Even regulators should be held to account for what they do. The regulatory framework should permit consensual powers of regulatory advice and consents to be given to NPOs, and it should have, most importantly, invasive powers of investigation and intervention in MPOs and enforcement and remedies which it can seek against MPOs. There may be, like in the case of fundraising in the UK, a notion of self-regulation by the sector and peer support by MPOs and charities of each other. That's an essential part of the framework of effective regulation, that MPOs or charities which are more substantial and which have more credibility in any sector help those who need further development. And regulatory bodies should be able to exchange information and evidence both within a country and internationally with other regulators and law enforcement agencies. And that's particularly important where MPOs or charities may be involved in terrorist activities or money laundering on a global scale. And finally, regulatory authorities must be held accountable for their decisions. Who regulates the regulators? Someone has to be regulating the regulators. In the UK, it's the courts and the tribunal. But they have to be held accountable for what they do in terms of their own regulation of the sector. I mentioned accountability and transparency in MPO regulation. This is one of the key factors for effective regulation in ensuring that the regulatory framework produces an accountable and transparent framework. Given the benefits and advantages of MPOs, the public must be able to understand what they are doing and what they contribute. Not only because the public, both in terms of volunteering and giving financial support, but where there are, of course, fiscal reliefs available to MPOs, this is a form of public subsidy. So what MPOs are actually doing with that public subsidy is a matter for all members of the public to be able to see. Some of the features of this support are listed on the slide. The public availability of a register and the availability of governing documents which govern MPOs and their accounts, and the enforcement of registration and financial returns and accounts by the regulatory authorities where these are not provided by MPOs. The legal framework itself imposes enforceable legal duties on those responsible for managing and controlling MPOs, and those legal duties are enforced in appropriate circumstances through civil sanctions, and of course where transgressions are particularly severe, through criminal sanctions. There should be a regulatory authority for considering and acting on complaints or concerns about MPOs, and public confidence in the MPO sector is seen as a key issue in regulation. And finally, accountability and transparency applies not only to MPOs but also to the regulator. The regulator itself should be open, accountable and transparent in what it does, and when it takes invasive remedies against an MPO, it must do so proportionally and on the basis of clear justification for what it's doing, and that can be tested through the legal system. I now want to look at regulation in the United Kingdom, an overview. Those familiar with the setup in the United Kingdom will know that the United Kingdom and Northern Ireland forms a comprehensive political system. But within that, Northern Ireland and Scotland, which are two essential elements of the United Kingdom, are devolved in terms of differing laws, political governance, and regulatory and other institutions. The law, Wales, also a constituent part of the United Kingdom, has an element of devolution, but the laws governing charities in Wales are the same as in England. So what we have essentially in terms of charity regulation is that the principal regulator of charities is for England and Wales, and that's the Charity Commission for England and Wales, and there's much smaller regulators for Scotland and for Northern Ireland. But those regulators are very much based on the Commission model. So we've got to focus really on the Charity Commission for England and Wales, and I'll start by having a look at the charitable sector, the regulated charitable sector in England and Wales. And you'll see from the slide that there are about 165,000 registered charities in England registered with the Charity Commission, and that includes about 13,000 working internationally. But the Commission is also responsible for bodies which are legally charities, which are not actually registered with the Commission. They're not required to register, and I'll come on to deal with that later on. But we think there's about 80,000 unregistered charities for which we are responsible as regulator. So that's a formidable size of a sector, although I learnt this morning that Korea itself has near on 200,000 MPOs working in the country. Looking at the value of that, the annual income we think is about £68 billion sterling of the sector, which we believe about 10 to 15 billion goes overseas. And this, in terms of its relationship to gross GDP, is about 4%, but we think a better approach is what we call a gross added value percentages, which is about 8%. But to put it in context, this is about the size of the agricultural industry in the United Kingdom, that's pretty big by any standard. So looking at the value of an output of the charitable sector in England and Wales is about the size of the agricultural industry. Its asset value is, we think, around 232 billion, but that will be an underestimate because the way charities value their assets, which are held not for financial gain, but for what we call purpose use, like a historic house, is not recorded in accounts at face value. But what is noticeable, I think, from the slide is the sheer diversity of the sector. 80% of the income is accounted for by only 3% of charities. And in fact, nearly 100,000 charities have an income of less than £25,000 sterling. So you see that there are some very, very wealthy charities in the United Kingdom and a large amount of smaller charities. And from a regulatory perspective, that makes regulation quite difficult, because we have to make our advice and guidance and our regulatory positioning deal with not only for the larger charities, which can afford, of course, the best financial advice, the best legal advice, and the best staff. We also have to make our guidance and our regulation applicable to very small organisations, which have no help and support except what they can glean very often from the Charity Commission. The sector employs about 820,000 paid staff, and there are about nearly 1 million trustees. These are the individuals which run charities and are generally unpaid. And in terms of the scale of volunteering, we think that 1 in every 20 persons actually volunteer or work for charity for nothing in any 1 year. That's what we see as a figure. So for a small country like UK, that's big by our standards. So Commission has a big job to do in terms of its regulation. Now I just want to look at the Commission itself and its regulatory functions. The Commission is classified as a non-ministerial government department. It's an independent civil regulator, and it's free from ministerial control or direction. It's a unitary body, it's the sole regulator for charities in England and Wales. It has a very old provenance. It was established in 1853, so that makes it the oldest regulator in the United Kingdom. And it acts as both the registrar and regulator of charity. The public register was introduced into the Commission in 1960. It's currently constituted under the Charities Act of 2011, and it has some statutory objectives. The primary one is to increase public trust and confidence in charities, is to ensure charities comply with the law, to promote their effectiveness and to enhance their accountability. And the scope of its regulation is to maintain a public register of charities, is to provide general advice and guidance on the proper and effective administration of charities. It confers regulatory advice and consents to charities. It monitors charities and investigates and remedies misconduct and maladministration in charities and the lack of compliance by charities, and it protects charitable property from misuse. And it obtains and evaluates and disseminates public information about charities. But it's quite a small organisation. We have a staff of about 290 people and a budget about £21 million sterling. We operate in London, Liverpool and Taunton and Newport. That's our Wales office, so across the country. And we are accountable to the Charity Tribunal and to the courts for our regulatory quasi-judicial decisions, and that's an essential element in our accountability. I just want to spend some time looking at how we position ourselves as the regulator. In the United Kingdom, the sector has been always lightly regulated, and it remains so. And this, in our view, has permitted the development of a thriving and independent charitable sector. But since the Commission was created in 1853, society, of course, has become much more complex, and charities, given the amount of money involved, is potentially open for abuse. And I highlight on the slide some of the vulnerable aspects of the sector. There's high levels of public trust in charities because of their voluntary and altruistic nature. They're relatively easy to set up. They reach all parts of society and are very diverse in nature. They provide powerful engines for social change, and they do attract people who are committed to change, sometimes change in a way which goes beyond the remit of what charities might do. They're powerful vehicles for bringing people together, and they have very often a global presence where money, goods and people cross boundaries, and that, of course, makes them open to potential criminality. They have global financial operations, and there's different levels of regulation in different countries. Nevertheless, the Commission has retained its light touch approach, engaging with charities on a very clear risk and proportionality framework. And we believe this has permitted the NGO sector to remain independent, effective and strong. However, there are high-risk areas where we have the capacity to and do intervene in charities' affairs, and I've highlighted these on the next slide. These are areas of high-risk areas for which we monitor charities. Quite obviously, the primary one is fraud and money laundering and running charities for private gain. Criminality by charities or involving charities. The third one is the abuse of vulnerable beneficiaries and safeguarding issues and protection of vulnerable beneficiaries. This is a big issue, not only in Europe, but particularly the UK and the US, and there's growing concerns about the historical cases of child abuse which have arisen in charities who are charged with looking after younger people and vulnerable adults. The fourth one, very rare but very corrosive of charities who have links to or support for terrorism. And this may be financial, or it may be the radicalization of young people. This is a very serious issue, both within the United Kingdom and internationally, as you will appreciate. Sham charities, charities which are set up for charitable purposes but intend to do the very opposite from day one. And these are very difficult to spot at registration stage. Charities who persistently fail to take action required by the regulator, as by the Commission, are high risk. And finally, charities with very poor governance and financial management within them. You're probably, those who read the UK press are probably aware of the charity Kids Company, which dealt with vulnerable beneficiaries, younger people, which collapsed spectacularly this summer, becoming insolvent. And there's issues there about whether the charity was effectively governed. But despite these areas of high risk, our approach is still in essence an enabling one, with intervention only where appropriate and only in clearly defined circumstances. But these areas do represent risk factors and are prioritized in the way we regulate charities. Just moving on now to the registration of charities. The public register is an essential element of Commission regulation. Charity is legally defined under the common law of England and Wales and under the Charities Act of 2011. They must be for a legally recognised purpose and be for the public benefit, and they cannot be established for political purposes, and they cannot carry out commercial trading themselves. Except for certain classes of charities, all charities with an income of over £5,000 sterling a year must register with the Commission. If they do not register, they can be required to register. The registration of charities in the UK is not a licensing system. It's not a license to operate. If you are a charity legally, you must register. It's a recognition of a legal status. And our enabling work, as I've said, a key element of regulation is to promote charity effectiveness, and we publish the rules by which charities need to be well known and observed. And the Commission assists in this by publishing general advice, and we have a website which that advice can be found on, and we have a call centre where trustees can ring up and ask questions of charities. And I've listed there on the slide some of our principal guidance. The Essential Trustee, for example, which sets out the duties and responsibilities of trustees. And it's your decision. That document sets out how trustees should make their decisions properly in the interest of the charity. And internal financial controls for charities. That's another piece of guidance which sets out guidance of how charities should run their affairs financially. We give specific statutory advice, and we give authority to facilitate charities' operations. I now want to look very briefly at our compliance functions. This is the sharp end of the Commission's regulatory work. We have to identify and investigate mismanagement and misconduct in charities. We need to assess complaints. We monitor charities. We carry out investigations and statutory inquiries, and we publish inquiry reports where we find wrongdoing, and regulatory case reports where we set out our results of an intervention with a charity. We have extensive powers of engagement with charities. We have ability to freeze bank accounts, restrain transactions of trustees. We can appoint an interim manager for a charity. We can suspend and remove trustees and appoint new trustees. And we can make remedial schemes and give directions to trustees to apply charity property. And we also have power to obtain warrants to enter and search premises where we believe there is material which evidences wrongdoing by charity trustees. And finally, we can take legal proceedings to recover charity property. And our public information functions of the Commission, the public register, we make an annual report to Parliament. We have an annual report calling Tackling Abuse and Mismanagement. We do research on public trust and confidence, which is also published, and we publish various documents like charities and public service delivery. These are for where charities receive money from the state to carry out functions which the state otherwise would carry out itself. I now want to look very briefly at the constitution of the Commission. The Commission is governed by a board, a non-executive board, and an executive. The non-executive board is comprised of a chairman and has between 4 and 8 members, and they're appointed after open competition as public appointments. They're actually appointed by ministers, but they go through what's called our public appointments processes. And the statute requires that collectively the Commission's board must have experience of charity law, accounts, and financing of charities, and the operation and regulation of charities. There must be 2 lawyers on the Commission's board, and a person with knowledge of conditions in Wales, given that Wales is an element of our regulatory remit. The executive is the body which actually runs the Commission, and there is a chief executive who is supported by a chief legal advisor, who is me, and there are compliance director and a policy and communications director and a corporate services director, and that goes to make up the directors group, which essentially runs the organisation. It's a civil service department, which means it's financed by government, but as I said before, it's independent and cannot be directed by ministers to take any course of action in relation to any charity. It's accountable for the exercise of its quasi-judicial powers to the Charity Tribunal and the courts. It's accountable to Parliament and parliamentary committees for its general conduct, and of course to the UK Treasury, which provides the funding for the Commission. And as an aspect of government, the Cabinet Office, the Office of Civil Society, is the body which we engage with as part of government, which deals with the policy towards the charitable sector. I just want to deal very briefly with how amenable the charity sector is in the United Kingdom and why it's easy to join and the advantages of joining. Well, as I said, charities are relatively easy to set up. A charity can be constituted in many different ways. There is a very positive benefits of being a charity. There's a very benign fiscal regime supporting charity. The advantage of being regulated by a single regulator, the Commission. There's certain legal immunities. It's characterized by a restriction on political activities and private benefit and trading activities. Historically, it's a lightly regulated sector, which encourages volunteering and financial giving, and is consensual in nature. And the Commission has a dual role in giving advice and support and compliance, and that's always been an essential aspect of the Commission's role since 1853. And we promote accountability and transparency in the charitable sector. And this lotus design, if I can call it that, maybe not a lotus design, sets out our strategic priorities. And you see at the heart of that is promoting public trust and confidence, which is underpinned by protecting charities from abuse and mismanagement and by assisting and supporting trustees, encouraging transparency and being an effective and efficient regulator. And as I said, our priority is to regulate in the public interest. That's also in the interest of the charitable sector, but it's in the public interest we regulate, not for the specific interests of the charitable sector. And I'll just sum up to conclude this address. We are and we encourage an enabling regulatory approach to the charitable NPO sector. The Commission has a developed relationship with the charitable sector, and regulation goes back 400 years to when the charitable sector was constituted in the UK. Historically, it was regulated by the courts, but for the last 150 years, it's been regulated primarily by the Commission. The charity sector is seen as an indispensable part of the UK economy and remains so. The role of the Commission is to facilitate healthy giving and developing a charitable sector which encourages volunteering and social and financial giving. Our regulation is seen internationally as the gold standard, but any NPO regulation needs to conform to the social, cultural and political legal systems in place in any country, and they must command public confidence in the country in which they are operative. No one size fits all, so I'm certainly not advocating a charity commission for Korea, but I would commend to you the principles under which the Commission operates as a charity regulator. Thank you.